Welcome. Thanks for joining us. You are here for the International Advertising Association's webinar on artificial intelligence in marketing, a global legal perspective focused on the Americas. This webinar is part of a webinar series that the IAA's Public Policy Council is doing on artificial intelligence this year in marketing. We're looking at some of the issues that marketers face when using AI tools and other artificial intelligence output in advertising. And so what we've done is we've gotten a group of people together from the Americas to talk about some of the issues we're thinking about in the US and Canada and in Mexico. This is part 2 of the series. The first part was Europe. So if you're interested in seeing what some of the issues are that we were thinking about in Europe, go to the IAA's website, which is iaaglobal.org, and you can find us in the public policy section. We've got our webinars there from not only from this year, but from prior years too, where we've covered different topics. Last year's topic, for example, is a 3-part series on environmental marketing. So we put together a panel together, and I think that maybe they will pop up on the screen in the way that those things happen. And you can see you've got Valdir Roca from Brazil, you've got Hannah Taylor, Pavana Kumar, and Melissa Steinman, all from the US. You've got Kelly Harris from Canada, and Jose Orochi from Mexico. So we're going to give you a broad perspective of some issues. You know, strangely, of course, a lot of the issues that we face in all these countries are the same. So we're not all going to talk about the exact same issues in every country, but instead we're going to try to each pick off some different issues and sort of give you a sample of the way that people are thinking about these issues around the world. I'm Jeff Greenbaum. I am the chair of the IAA's Public Policy Council. I wear lots of different hats. One of the hats that I wear is as chairman of the Global Advertising Lawyers Alliance, and Gala has partnered with IAA to put on this webinar series. And all of these people on the webinar today are members of the Global Advertising Lawyers Alliance. So with that very brief introduction, I'm going to kick it off to Hannah to talk a little bit about both artificial intelligence and the IP issues. So okay. Here we go.
Thank you. Perfect. Okay, so many of you probably at this point know what AI is, but we want to do some level setting for the audience just to make sure that we're all on the same page thinking about what we're talking about today. So AI, as many of you obviously know, stands for artificial intelligence. But the kind of artificial intelligence that's out there can actually vary quite widely. We've seen artificial intelligence in our consumer-facing products for years, right? You watch Netflix recommend a show for you. That's likely being done using artificial intelligence. You may have a Siri or an Alexa. All of that is, you know, the simulation of human intelligence through machines. Today, particularly because it's what most matters to marketers, we're going to be talking particularly about generative AI. And generative AI is a type of artificial intelligence that is usually trained on large quantities of data that interacts with a person using text, audio, or visual communication, and then generates non-scripted outputs that are similar to something that would be created by a human. So I'll give you an example if we could go to the next slide. So I went to ChatGPT in preparation for this presentation, and I asked it, can you please provide me with a photo of an advertising lawyer? And this is what it provided. Query as to whether or not, you know, this has all sorts of bias and other issues that we'll talk about later, but this is a good example of a sort of the way that most consumers or advertisers are using these tools to generate content or output. I put in a prompt, which was the, you know, create a photo of an advertising lawyer, and I waited all of 5 seconds, and ChatGPT, using its DALL-E functionality, was able to create an image for me. So we're seeing this come up in people's work lives, and particularly in creating advertising materials. So if you could go to the next slide. Here are 2 examples that I think are interesting to think about how these types of tools are playing out in the real world. So Qatar Airways recently created an entire ad campaign where consumers could scan their faces using biometric technology provided on a website by the airline, and they could actually, using AI technology, put their own face into an ad and watch themselves move around within a piece of creative. And Qatar Airways did a big PR push saying that this was the first interactive AI campaign ever created by an advertiser. So we're seeing that, there are all sorts of exciting creative decisions being made by brands using AI technology. Now, on the right, there was a fake Volvo ad that went viral because a colorist, just a random guy out there in the universe, who does not work for Volvo, does not work for an ad agency connected to Volvo, but just a regular consumer, used Runway, the AI tool, generative AI tool, and prompted it to create a Volvo ad. And what ensued was a very realistic looking ad for Volvo. And the internet went crazy over the fact that this took less than one day, and using very little information, but having the tools available to him, this guy was able to create what normally would have taken an advertiser millions of dollars and many months, if not years, to create. So we are at the precipice of a very exciting time in AI, but also raises lots of legal and ethical issues, which we will get into going forward. So I am now going to talk about the intellectual property issues with using these types of generative AI tools. There are many, but we're going to go over sort of the high level. So there's sort of two ways that we think about intellectual property issues when it comes to using generative AI. The first is what we call input, which basically means all the data that the AI tool has used, or in some instances scraped, to populate in order to make the model run. And then when we say output, we basically mean the results that come from using generative AI tools, like, for example, the photo of the advertising lawyer that I showed you before. And the legal issues on the IP side come from both the input side and the output side. And we'll talk a bit about how courts are thinking about both of those different issues. Next slide. So looks like something odd's happening with the slide here, but I don't know why there's a black line over the slide, but it doesn't matter. So right now, sort of big picture, there are big major sort of topics that many of the court cases are handling, particularly in the US when it comes to IP and artificial intelligence. So right now in the US, we have more than 30 pending cases challenging IP related issues with generative AI platforms. And most of the cases deal with copyright issues. And we've seen most of the litigation focus on the input side. And what I mean by that is you see owners of major swaths of intellectual property, whether it's movie studios, authors of books, newspapers, any other sort of broad copyright holders, suing the makers of artificial intelligence tools like OpenAI and Meta, basically saying, you make your tools work by scraping or ingesting huge amounts of our copyrighted material. And that in and of itself is infringement, because you are essentially ingesting our copyrighted material without permission. There are other claims that we've seen, including trademark infringement and right of publicity, but those have been a little bit less of the focus. So if we go to the next slide, when you dig down into the cases, very few of which, actually, we really have almost no final decisions. We've had some interesting pieces of motion practice, which we'll get into, but we have no final decisions on the books yet. When you get into what the courts are looking at and what the various parties are arguing over, it really is over whether or not it is copyright infringement to take original works of authorship that have been fixed in a tangible medium, which is what copyright law in America requires, and uses that material without permission to train the model. And the defense from many of the AI models is, sure, we are taking, in many instances, large swaths of data, including some copyright protected data, but we are not just using it for the purpose in which it was originally created. We are making a transformative use out of it. And there's lots of case law in the US in particular that even if you are using copyrighted material, if your use is transformative, it might be protected under the defense to copyright infringement called fair use. We are waiting to see how the courts decide whether or not all of this data scraping or even ingestion of material in other forms could be considered copyright infringement, but that's the main argument. Next slide, please. Then the next question is whether or not the output, again, like the photo of the advertising lawyer that I showed you using ChatGPT, whether or not that output that comes from the models could in and of itself also be considered infringing works. The argument in all of these cases, again, is that the outputs from the tools are creating infringing derivative works. So if you've ingested, a particular Getty photo, for example, this is one thing that Getty is alleging in one of its lawsuits, and then the output looks very similar to the original Getty photo, well, then maybe that output is an infringing derivative work of the original photo. We are seeing interesting steps in these cases to sort of hone those arguments. So if we could go to the next slide, I'll talk about one of them in particular. So one of the most successful cases so far has been a case brought by the New York Times against OpenAI for use of its paywalled articles ingested into the OpenAI tool, and then showing, as this image does, output that comes from tools like ChatGPT that replicate copyrighted articles from the New York Times. And the New York Times has been fairly successful at showing in its exhibits as part of the lawsuit that when you use ChatGPT and try to get it to replicate certain New York Times articles, the AI tool actually replicates the content pretty much wholesale. And so their argument is it's not really all that transformative. It's pretty much an infringing derivative work if ChatGPT can actually ingest my article and then basically repeat it wholesale as part of the output. And courts are starting to say, if the output is substantially similar to the existing piece of copyrighted material, the plaintiffs might actually have an argument. So that's what we're watching very closely in the US from an IP perspective when it comes to the copyright cases. Next slide, please. We also don't just worry about infringement when it comes to thinking about the holistic ways in which copyright's going to be affected by the generative AI tools. We also have to think about protectability. And what I mean by protectability is, can I get a copyright in something that was created using AI tools? And right now in the US, the Copyright Office has taken a pretty strict position that only human authorship is protectable and ownable. Now, it doesn't mean that you can't use AI tools at all if you want to get copyright protection, but usually the way that the Copyright Office is going to think about it is that they're going to allow protectability on the pieces that you can show really were created by a human, and they're going to exclude from protectability that which is created by machines. And that can get quite hard to do, and it's part of the reason why when we counsel in this area, we want to make sure that we're creating documents that show exactly what types of prompts were created by humans or what we can attribute to human authorship as opposed to what we could attribute to something that might be created particularly by the tool itself, in order to try to get as much ownability or protectability as possible. Next slide, please. So there are some other practical considerations to think about when it comes to IP protectability as well. One of the things that's challenging about using these AI tools is not just the infringement issues or whether or not you might be able to get a copyright registration, but the fact that many of the tools explicitly say in their terms of service that they are going to create similar materials for other people that are using the tool. So if someone else goes on to ChatGPT and asks for a photo of an advertising lawyer, they might get the exact same output that I got. And so if you are an advertiser looking to have a very specific advertising campaign where you can keep your competitors from being able to use similar creative, AI tools can be dicey because you can't stop others from having the same output given to them or from necessarily using it, because it's not yours or protectable in the same way that creative created entirely in-house might be, or by your agencies. And you also can see, even from the OpenAI terms of service, it says, due to the nature of machine learning, output may not be unique. So, you really, if you're looking to create something that's just yours, AI tools can be a little bit challenging. Next slide, please. I mentioned before that the bulk of the discussion when it comes to generative AI tools has been about copyright infringement, but trademark infringement has been asserted as well. Here's an example of an actual exhibit from the lawsuit brought by Getty Images for ingestion of many of its copyrighted photos into a major generative AI platform. And in addition to the copyright claim that they brought for use of their photos, they also brought a trademark infringement claim for the fact that their watermark, which shows the Getty image trademark, was used and ingested into the AI tool, and then when it was spit back out was diluted or garbled in the output. And the allegation is that the altered trademarks basically make the Getty mark look lower quality or unappealing, which could dilute the mark. And so this is an interesting way to think about trademark law, in addition to some of the copyright issues that we've already seen. Next slide, please. Valdir will talk more in depth about the right of publicity issues that come from things like deep fakes, but we should note that sort of standard right of publicity issues exist in the US, particularly when it comes to use of people's voice and likeness as ingested into certain AI tools. We've seen many famous examples of this, like Taylor Swift, for example, seeming to endorse Donald Trump when the images had been created with AI. And many different states are grappling with how to update the right of publicity legal scheme, which now has 50 state laws in the United States, mostly geared towards protection of someone's persona in a commercial context, to contemplate the idea that use of your likeness, even outside of a commercial context, if it's done in a way that might be without your permission and in a way that might be fake or cause harm to you, that the laws might need updating or broadening beyond just what's in the commercial context. So we've seen Tennessee be the first state to pass a law like this. Tennessee's Ensuring Likeness, Voice, and Image Security Act, called the Elvis Act, was the first U.S. law to restrict use of AI for right of publicity reasons, including deepfakes and voice cloning. That came out in July 1st of 2024. And it's important to note that the law is beyond advertising uses. It goes to any use of someone's likeness, voice, and image for ingestion into AI tools without their permission. Next slide, please. So what are some of the things that you can do from a practical perspective to deal with all of this gray area? Many of the answers are going to be in looking at what types of tools you're using. So some of these tools, if you're just using the open source off-the-shelf version as an advertiser, or if your agency is, won't give you warranties of any kind, or they won't necessarily give you an indemnity. But many of them are actually starting to give what's called enterprise licenses, where they allow for a broader level of protection for use of some of the output. And so really look into what platform you're using, what the applicable terms are, could in fact help mitigate some of the practical risk when using the tools in advertising. And I believe that's it for me, but
Great. Thanks, Hannah. And so we're going to go right to Valdir and talk about deepfakes.
Hello, everybody. My name is Valdir Rocha. I'm a partner of Beirano Law Firm in Brazil. And I wish to thank Hannah for making my job easier. She addressed rights of publicity, which in civil law jurisdictions is called rights of personality, basically image rights and voice rights. So next slide, please. Next slide. So what is a deep fake? Deep fake is something done with the use of AI to change people's faces or voice, or using or mimicking their speech or their face with some purpose, usually with the purpose of criticism or to sell goods without the person's permission. Next, please. So the first case of deep fake but authorized that we had was the Volkswagen commercial. Volkswagen hired the daughter of a late singer, that the one appearing on the screen. Elis Regina was the most popular singer in Brazil in the 60s and 70s. She died very young at the age of 37 of overdose and left three children. One is a music producer today, and the two others are singers. So Volkswagen used a model and created and put the face of the singer and animated the face of the singer on that model and created a commercial in which the late singer drives an old Volkswagen bus and her daughter drives an electric Volkswagen bus, and they drive side by side singing a protest song from the 70s, which was composed by Belchior. So the friends of Elis Regina and Belchior were outraged because they would never have authorized use of their image and song in that commercial. And they took it to CONAR, the Brazilian self-regulation body. But CONAR said there was nothing illegal because all the heirs authorized use of the image and the song. And it was an ethical issue which was not to be decided by CONAR and dismissed the case. Next, please. So the second case, which was aired last month in Brazil, and Will Smith was here in Rio for the Rock in Rio Festival, was the commercial of Nomad. Nomad is a Brazilian fintech that provides coin cards for travelers. And Will Smith starts speaking English in the commercial, and then suddenly it changes to Portuguese. It's a perfect Portuguese with his tone of voice and everything. So of course he was paid to do that, and it's a deep fake authorized and paid for. Next. So this is deep fake in art. We are seeing now deep fakes changing paintings, and in this case, the designer Acoca, Mr. Acoca, used AI to create a 360 experience of Las Meninas by Velázquez, Spanish painter. But the painter died more than 300 years ago, so the work of art is in the public domain, and no rights were violated in that. And that type of AI use can be also used in advertising. Next. What are the challenges and risks of deepfake? It causes disinformation. It can violate privacy, and it can damage reputation. So we're going to see some examples that could damage the reputation of these celebrities. Next, please. First of all is Dr. Drauzio Varela. He's very famous in Brazil, probably as popular as Dr. Fauci was in the US during the pandemic. So was Dr. Varela. He spoke on TV. He's always on TV. And someone used his image and his voice and manipulated with AI his image and voice to advertise drugs without his permission. So he sued and obtained a court-ordered injunction to ban the ad. Next, please. The second one is Marcos Mion, also a TV host. His son has autism, and his image and voice were used to promote an unregistered medicine to cure autism. As far as I know, the case has not been litigated. Next. This one involves religious leaders. There are some pastors, evangelical pastors in Brazil who have become celebrities, and some Catholic priests who are also celebrities. There are two priests there. Both of them are singers and writers, and they have millions and millions of followers. And on the other side, there's a pastor next to the former president who he's supported. The image of these religious leaders was used to sell drugs in medicines in meta platforms, and this is a case that could lead to notices of takedown. Most platforms operating in Brazil accept notice of takedown when there is trademark infringement, proven copyright infringement, and of course the use of image and voice without permission. We have 72 bills of law pending in Congress related to AI. There's one proposed by the president of the Senate, which is moving forward and faster, and it's inspired in the European AI Act, just like the Brazilian LGPD was inspired in the GDPR. So we don't have a law, but the Brazilian Superior Electoral Court (TSC) had to regulate the use of deepfakes and AI in electoral advertising, because we have municipal elections this year. We have more than 5,700 counties, and all these counties will have elections for mayors and city councils. So there is a lot of campaigning going on all over the place, and deep fakes were being used, but now they're prohibited by the electoral court. Next, please. And one case of deep fake done by politicians, but before the electoral period, was the use of Ryan Gosling's image mixed with the face of the mayor of São Paulo. Ken in Portuguese is pronounced like quem, which means who, and the mayor was not very well known. So his opponent, Tabata Amaral, a very young politician, I think she's 30 years old, she's running for mayor in São Paulo against the current mayor, and she used that picture. She made a video criticizing the mayor because he was unknown by the public. So prefeito quem means mayor who, and mixing, it's a wordplay with the mixture of the face of Ryan Gosling and the mayor. So the mayor sued her, but the court understood that it was criticism. It was prior to the electoral campaign, and it was not advertising, electoral advertising. So the case was dismissed.
All right.
So,
thanks,
these are the cases from Brazil.
All right. Thanks a lot. All right. We're going to switch gears now, and we're going to talk. Pavana's going to talk about consumer protection issues arising out of the use of generative AI. And so, Pavana, you're up.
Great. Thanks, Jeff. Again, I'm Pavana Kumar. I am a partner in the advertising and marketing group at Davis and Gilbert. So we're going to shift gears a little bit to consumer protection issues. So many of you may have heard the buzzword dark patterns, which is an FTC and regulatory priority right now. Broadly speaking, there are a lot of different definitions, including under privacy laws, but broadly speaking, dark patterns are the use of deceptive design tactics intended to trap or trick consumers into taking an action they wouldn't otherwise have taken. So it can be difficult for companies to toe the line between, what's acceptable advertising, because the purpose of advertising is to get consumers to buy your product, right? But then there's a line between that and dark patterns, which is the use of manipulative techniques to achieve that goal. So, the introduction and evolution of AI is certainly not making the exercise of towing that line any easier. So we're going to talk about a few examples of how AI can operationally enhance those deceptive tactics. I don't have a slide on this because the FTC literally issued a press release about an hour ago announcing an enforcement sweep called Operation AI Comply against 5 pretty big companies, ranging from challenging tactics of using AI to generate fake reviews to the use of AI to generate fake claims, such as fake claims of expertise in a given area or in a given industry, and the use of AI to generate deceptive earnings claims and similar issues. So this is certainly very, very timely. I would encourage anyone that hasn't already seen this to check out the press release because it's very instructive of where the regulators' minds are on this topic. So let's go to the next slide. So why is AI sort of accelerating the potential use of dark patterns? As our panelists have already touched on, obviously AI can ingest a huge amount of data, but that also includes behavioral data. And so use of AI can enhance the ability of advertisers and marketers to tailor dark patterns to target particular peoples and particular demographics, preferences, the behaviors, and vulnerabilities. Specifically, for example, if an AI chatbot is giving medical advice, financial advice, advice to sensitive groups, AI can really be used to hyper-personalize those messages and further undermine users' choice. So it's a really evolving and very interesting topic. So let's move on to some examples. So another thing about generative AI is that it can learn and adapt in real time to users' responses. So where a traditional dark pattern may involve, say, it's a deceptive countdown clock on a website, a user journey that's confusing and difficult to navigate, AI can make that even more difficult because it can see where the vulnerabilities are and adapt in real time to make it even more difficult for a consumer to escape from a potentially deceptive or confusing user flow. So let's move on. So some of you might be thinking, is it really possible for a consumer to believe they're speaking with a real person versus interacting with an AI system? Absolutely. Even way back when ChatGPT was first coming into the news, there was this great New York Times article about a journalist who had a very interesting experience interacting with ChatGPT, really a high level of emotional intelligence, more than we really thought was possible. There was a recent experiment run by this AI startup called Human or Not, where they paired players up for 2-minute conversations, and after that, they had to guess whether they were speaking with a human or an AI chatbot. When talking to bots, you can see these statistics. They only guessed right in 60% of the cases. So it's really possible for consumers to be deceived in various contexts, whether it's customer service, interaction with a virtual influencer, or otherwise, that they're speaking with a real person. And that can really be material to someone's perception of the interaction. And we'll get to some examples in the subsequent slides if we go to the next one. So here's an example of how interactions with AI systems can enhance certain types of dark patterns. Some more traditional dark patterns might be the practices of unauthorized upsells, drip pricing tactics where fees are hidden till the last stage of a flow, junk fees, and similar. So AI really enhances the ability of companies to engage in these tactics in what I'd call a more insidious way. Certain companies have been testing out AI systems that can take customer orders at drive-thrus, but also look at prior customer behavior to tailor certain upsells. So that's a problem potentially from a dark patterns perspective. Also from a consumer unfairness perspective, if you're using data that you know about that consumer to serve them a different price or a different upsell that a different consumer would receive. I think this is something we're going to see a lot more of going forward, and something that companies need to be very careful about, even if it's just in the beta phase or in the testing phase. Next slide. So more broadly, the FTC is obviously extremely focused on misleading advertising, such as the use of fake reviews and endorsements and testimonials. The FTC recently updated its guides relating to endorsements and testimonials, and just last month, they issued their final rule on consumer reviews. And in both of those, the FTC has emphasized that generative AI can enhance the problem. Generative AI can create fake reviews that are difficult to distinguish from real reviews. One of the cases announced today was against a company that did exactly that. And as Valdir's touched on, as I'm sure Jose will also talk about with respect to influencers and reviews, deceptive content will make use of these deep fakes. That can create the appearance of fake celebrity endorsements. But something else the FTC also emphasized is that if a company is using a virtual influencer, for example, even if it's not recreating a celebrity, the fact that the influencer is virtual and not real is something that may need to be disclosed alongside the traditional material connection between the brand and the influencer that would need to be disclosed under existing law anyway. Next slide. This one's an interesting example just because it was highly publicized. This was a case in which a consumer who was recently bereaved asked Air Canada's chatbot if he could receive a refund in the event of bereavement. The AI told him that he could. It spit out an entire refund policy. It turned out that wasn't Air Canada's policy, and they actually declined to uphold it. This actually went to small claims court, which I think is crazy because Air Canada was really doubling down on the falsities that its chatbot spit out. But it's just a reminder that, from a consumer perspective, they may be relying on a chatbot. It may even be holding itself out as an expert. as outlined in some of the FTC's cases today, whether it's a legal expert, a customer service expert, and consumers may be relying on those representations. So it's really important to vet any AI consumer interacting device or chatbot to make sure that it's spitting out correct information, or otherwise that the appropriate caveats are being made, and also potentially to honor any false information that the AI chatbot communicates to consumers. Next slide. I think this is a really interesting example. I think this is the second time we've mentioned Taylor Swift today. This went viral. These were some AI-generated video scans that tricked consumers into believing Taylor Swift was giving away free sets of cookware. This is obviously a deep fake that replicates her voice and appearance. So you have your right of publicity issues there, your false association issues. Then it's also being used to perpetuate a dark pattern, right? Because consumers are likely to rely on the celebrity endorsement to be more likely to go and sign up for this product, which, by the way, was not actually free, and they ended up getting enrolled into a subscription program and charged shipping fees too. So plenty of dark patterns there, but it's a good illustration of the many pitfalls companies can get into if they're using AI to replicate celebrities, in addition to the state-by-state laws that Hannah already mentioned. And then just finally, use of AI to generate advertising in of itself. Similarly to the virtual influencer analysis, depending on what the AI is being used to do, it may be a good idea to disclose the AI was used to generate or to power the ad. If you're just using AI in the same way you'd use a post-production company, sharpen up an image, formatting, perhaps that's not material. If it's being used to recreate sets or demonstrations, it may be more material. So that's just something to keep in mind when developing advertising from a consumer protection perspective.
All right.
All right, I think that's it from me. I want to make sure everyone else has time to delve into these important topics too.
Thanks, Pavana. That's just great. Okay, we're going to switch now to the topic of consumer reviews, and we're going to look at it from the perspective of what's going on in Mexico. Jose?
Hi, Jeff. Thank you very much for everything. Pavana, thank you. Well, my name is Jose Antonio Arochi, and I'm a partner at Arochi Linder here in Mexico. Well, first of all, as we all know, consumer reviews were very big or have been growing so much since after pandemic. I think in a day by day, we are going inside and acquiring products or services in different e-commerce web pages. And I believe the first question we have in Mexico, can we change to the other slide, Jeff? Thank you very much. Is there any regulation related to consumer reviews in Mexico? Unfortunately, in Mexico, we don't have a regulation that talks about consumer reviews, and it gets a little bit tricky because it's being a very big tool for companies to use it to criticize their competition or to try to get an advantage from their competition, because obviously they can manipulate everything regarding consumer reviews. Can we change slide, please? So at the end, obviously, when we go as consumer and we acquire, for example, I go to Airbnb and I want to rent a place, I will always look on the reviews to see if actually it's a house that I would stay and rent. Or even if I go to Amazon and I want to buy a product, I will always see the stars. The problem here in Mexico is that you, like I mentioned before, you're starting to see a lot of very good reviews that are very well written, and you can see that at the end the problem is that there is a third party doing these reviews, like I mentioned, to try to obtain a benefit from it or to try to criticize or bring down their competition. And obviously, if there is no type of regulation, obviously people abuse about it. And bringing into effect that we can use AI with all of the data that we recollect, and it can be done in a daily basis. Well, the government here in Mexico have to analyze that if they haven't regulated consumer reviews, these consumer reviews have to be regulated with an added value, which would be AI, which is right now it's a reality. Can we do the other slide, please? So at the end, this is a very cool example here. We have this is Lili Miquela, which is an influencer that is being operated by AI. Lili Miquela talks about jarritos, which is one of the biggest Latin or Mexican soda sold in the United States. We see Limiquela eating Reese's Pieces, and we see Limiquela talking about the new iX2 BMW and saying that that she has driven this car, that she has been eating this chocolate, that she has been drinking this soda. So at the end, how can an AI operated influencer can say this types of actions? At the end, obviously, it can be confused for misleading advertisement. So at the end, what we have been pushing a little bit the authorities here in Mexico. There has been a lot of changes, or there's going to be a lot of changes with the new government that will start getting, and we're going to start seeing more cases regarding AI, including privacy, because they're saying that the privacy entity that regulates in Mexico will be part of the Mexican FTC, which is Profeco. So we're going to start to see a lot of issues regarding that. But what I'm saying here is, imagine you have an AI influencer talking about or giving an opinion of what she's using or what she's eating or drinking. And at the end, obviously, it is in the thin line of saying that there's misleading advertisement. But at the end, the question is, who is liable for this? No? Can we go to the other slide, please? So at the end, as I mentioned, we don't have a regulatory framework in Mexico regarding consumer reviews. Just so you know, in Mexico, we have one article that regulates advertising, which is Article 32 of the Consumer Protection Law, that talks about misleading advertisement and how advertising has to be established. And at the end, it's something that we've been, as industry, we have been trying to push for the government to get more regulations, because we start seeing a lot of cases that at the end, we have to see if this type of cases should be seen before the Mexican PTO for unlawful competition or before the Mexican Consumer Protection. Even the Mexican FDA regulates some type of publicity. So at the end, there is lack of regulation. There is no regulatory framework. And at the end, we have to be, as lawyers, trying to improvise to see what is the authority regulating this type of matters. So at the end, the regulation that we've been trying to push and have as a regulatory framework should be trying to prevent fake reviews, like we've been talking about in the webinar, obviously generated by AI reviews, justify the review quality of the relationship, create a sanction regime at the end. Who is liable for this? The company, the brands. You saw that the case of the influencer that I was talking. Obviously prohibiting the use of bots, which obviously is the day-by-day working, and obviously they are writing reviews in a daily basis. Provision to write false reviews to affect competitors. This happens in a daily basis in Mexico. So at the end, in Mexico, you can file a complaint, and it can be anonymous in the first instance, saying that you're a consumer and saying that X company is affecting for A, B, and C. And obviously, they can get a benefit out of it. Obviously, avoid dark patterns, like Valdir was talking, what is a dark pattern, and obviously prevent manipulations of reviews, which is the biggest thing that happens here in Mexico. Can we change the... So at the end, as I was mentioning, I think the consumer protection regulations talks about truthfulness and transparency in the promotion of products. And we believe that virtual influencers should be regulated in these new provisions that we're trying to push, talking to the legislative power here in Mexico. I think things will change. That now the former head of the Mexican Consumer Protection Agency is a senator. So I'm seeing a lot that he's trying to push for new regulations that will regulate this authority. And maybe we'll start to have more regulations, because now, as him being a senator and him being in the past 6 years as the head of the Mexican FTC, well, we'll maybe see a lot of changes. So the companies have to be prevent of what's happening, no? So the consumer and virtual influencers review 101, what I would say is virtual users may be created by AI tools, content created with machine learning, Thank you very much. Who's the author of the content? Like I was mentioning, I think that this is the most important thing. Who's responsible of the content? Like the example that I gave you regarding the influencer talking about drinking the jarrito soda, about eating the Reese's Pieces, or about using the car or driving the car. Who's responsible of this misleading advertisement? Obviously, commercial strategy, alliances, inability to truly experience a product. And I think the main target for this is Generation C, because obviously this is who is seeing this type of promotions. This AI influencer is very famous in Mexico, and she is the stereotype of cute girl with pink hair, and at the end she's very followed. So she talks a lot about food routines, and at the end, like I mentioned, if you don't have a regulated framework in your jurisdiction, it's very complicated to try to stop this type of advertising. And this is the best practices that when we try to talk with the different agencies or different clients of us, we always tell them, please using the indicators of the AD, 3D, and if it has IAG generated, even though there is just a guideline, which is new from the Mexican FTC, that talks about what influencers can do and what they can't do. And they say it's not binding, but obviously it's binding. We always, when we do all the clearance for the advertising and publicity of our clients, we recommend that they establish the AI generated and fiction, so the consumer can see that it's not done by the human being, but it comes with a AI generated technology. Thank you very much.
All right, thanks, Jose. And so with half the world's population having elections this year, we thought we should touch on political advertising. Melissa?
Thanks, Jeff. Of course, the U.S. has a very highly contested election. I think many people know that this year. So AI has become a big issue. I think at the beginning of the year, last year, we thought there would be a lot of regulation coming in with AI. While there has been a lot of discussion, there maybe has been a little less in terms of new law than we thought, but there has been regulation. So let's talk about it. In a lot of ways, incorporating AI into political advertising probably isn't that harmful. We don't necessarily care if a candidate is using AI to hide their gray hair. There may even be potential good uses in the sense that AI could be used to democratize, in the sense of small d, campaigns in that technology makes it easier and cheaper for less well-funded campaigns and candidates to create content from limited resources. But there's a general agreement that AI has the power to harm democracy, of course, because it has the potential to mislead voters. So there's been many attempts to regulate at the federal and state level, starting with, next slide, an executive order that was issued by, not really starting with, but probably the most prominent being an executive order from President Biden last year, which was executive order on the safe, secure, and trustworthy development and use of AI, which did generally talk about how to maybe pass regulations, standards, best practices for developing and using AI, but it also talked about AI in governance and government, privacy, and all that. So we have that as sort of baseline principles from which a lot of what we've talked about in terms of the US model came from or continued to follow. Now, in terms of some examples we've seen, we'll talk about them a little bit throughout, but to start with, on the next slide, we see two examples. The first was a robocall that ran in New Hampshire just before the Democratic presidential primary, which obviously contained incorrect information. It was disseminated to potential voters by phone using a voice that sounded like Joe Biden. It ultimately and obviously purveyed false information about how Republicans that had been trying to push nonpartisan and democratic voters to participate in the primary, which was what a bunch of malarkey, which of course was language like Joe Biden used, being, somewhere early in, the century, not something that really the youngsters were, to use another Joe Biden term, connecting with, but sort of saying, oh, it's important to save your vote for the November election, something trying to keep people away from the primaries. Voting this Tuesday only enables the Republicans in their quest to elect Trump again. So you can see how this would be damaging. So ultimately, that resulted in a $1 million fine from the FCC for the VoIP service operator that sent it. And then the action against the person who paid for that ad, Steve Kramer, the FCC has proposed a $6 million fine, and he also faces criminal charges. The FCC, as we'll talk about in a bit, has been pursuing actions like this under the existing TCPA, the Telephone Consumer Protection Act. So it's an example of how some of existing laws are being used against some of this political advertising, and how the FCC is going after this sort of thing. The second example here are snips from a video posted by DeSantis operatives, which depicts something which did not happen. Trump kissing Fauci. We know how Trump feels about Anthony Fauci, who is formerly head of NIH, head of the COVID efforts at NIH, and had no disclaimer about the fact that it was created by AI. Very misleading. Makes Trump look like his efforts with COVID were perhaps different, let's just say, than they were, that the relationship was different. So we're going to talk a little bit about regulation, the federal and then the states, how they're regulating, and in particular, how they're allocating liability between payer and platform. Next slide. One of the interesting things with the US model here, as opposed to maybe the model in Europe or Mexico, Canada, is that political speech is very highly protected in the US, much more so than commercial speech, which we've already talked about in the form of, ads for consumer products or the like. Any effort to restrict or prevent AI-generated messages of a political nature is going to be met with heavy resistance under the First Amendment. We've seen this historically in courts ruling that laws prohibiting false statements about a candidate are unconstitutional. But there are, of course, legitimate state interests in preventing voter deception and intimidation, so that in the past, laws that would give voters false, deceptive information, those laws have been permitted to remain in effect. For example, it's illegal in most states to distribute advertising to voters telling them election day is November 6th if it's actually November 5th. So any solution involving AI is going to have to balance those interests. Generally, we've seen two kinds of approaches in regulating the use of AI: bans and labeling requirements. I think we're going to continue to see that. So bans generally are going to be unlikely to survive judicial scrutiny as a prior restraint on political speech. But labeling, we're seeing a lot of requirements to add labels to advertising that includes AI. And those are more likely to pass constitutional muster, whether it's commercial speech or especially political speech. Now, advertisers, all of us that work with them or that are them, are hate disclosures, hate disclaimers. but it's not a foreign concept, especially in the political space. Paid for by such and such committee, so and so is responsible for this advertising. They're commonplace, so they're more likely to be palatable in the political space. In terms of who's regulating, next slide, it's not entirely clear who is regulating, who's in charge of regulating AI and political advertising. Generally speaking, federal law, the Federal Election Commission governs regulating advertising for elections and foreign advertisings like the president, the Senate, the US House, and state law and state regulators regulate, and we're talking about secretaries of state, state attorneys general, govern advertising in local or state elections. So at the federal level, we're talking about the Federal Election Commission and FEC regulations, which prohibit candidates from impersonating another candidate or impersonating a candidate for purposes of raising money. However, they don't prohibit advertising right now from misrepresenting a candidate without pretending to actually be that candidate. So you can't prohibit President Biden from disseminating an ad depicting former President Trump saying something embarrassing he did not do or say, as long as it's clear that President Biden is responsible for that ad. So that Trump Fauci copy that we saw is currently acceptable. You do want to, individual social media companies have adopted, however, internal AI policies so that can be used to regulate there. But that's, of course, private entities. The FEC just had a hearing, so we'll talk about that in a minute. It's yet to put forth a proposed rule, and the FEC is actually skeptical of whether the existing statute on impersonation gives them the power to really do much, and is kind of waiting for Congress to act. There are several pending bills. The Are You Real Political Advertisements Act, AI Transparency and Elections Act, but they will not take effect unless there's really quick action at this point. It's something to watch for in upcoming years rather than this election cycle. There's also an FCC rulemaking ongoing. First, the FCC has ruled that phone calls that use AI technologies to simulate human voices to obtain the express consent or express written consent of recipients before calls are placed to residential or wireless numbers are illegal unless an emergency purpose or TCPA exemption applies. Second, the FCC issued an NPRM in August, which won't be in place before this election, but it does not target internet advertising, so digital streaming not impacted. It proposes that stations be required to inquire whether ads contain AI-generated content and inform them that a disclaimer is required, and offers proposed language. The other thing to consider is that Section 230 of the CDA will apply to political advertising that is done digitally, which is most. And so you need to factor in laws like that in terms of whether, the FCC or other, whether platforms can actually be held responsible for deceptive online content when counseling. As I mentioned on the net, and we can look at the next slide now, the FEC actually had a hearing last week deliberating whether AI, in how to regulate AI in political advertising. Ultimately, it did not agree on its authority to expand regulation, and so it did not act at this time. They issued an interpretive statement, essentially saying that federal campaign laws are technology neutral, and anything currently regulated under the law will be prohibited whether or not AI is involved. So things like the TCPA regulations, or anything we've just discussed, it'll regulate AI, but they have not extended or adopted AI specific laws at this time. They have voted against opening a specific rulemaking, and they're basically waiting for Congress to act on this. So still no impersonation of other candidates, no misrepresentation, but you cannot, there's going to be no new law, I think, before the election. So on to the states. On the next slide, there are at least 18 states that have adopted legislation, but this is really going to apply mostly to the state elections, is at least, the current thought. They vary on key issues. So there's really a patchwork here. Ban versus disclaimer. Some states have outright banned the use of AI in electioneering, but most states have implemented disclosure requirements. There's also variation in what media will be covered. But generally, the common themes are things like content has to depict something that actually happened. It should have a convincing appearance. It needs to be developed by it needs to be real. So in terms of liability, similarly, there's different approaches to who will be liable. Generally, whoever paid for the content is going to be liable, but there are different approaches to whether the platform will be liable, whether, the platform will be exempt from liability. Some platforms may not be liable, like the broadcast platforms often are carved out. Sometimes there's an intent requirement. So lots of variations in the laws. Probably the most activist here has been California, which is discussed on the next slide. There are a number of recently enacted bills in California, some of which are listed here. There was sort of a package, I think many know of, that were recently adopted with respect to AI. Mostly the focus in California is on disclosure, like in a lot of states. But in addition, this AB 2655, which is the second bill that's listed, requires large online platforms to label or remove misleading content related to elections, and election officials, the AG, the DA, are authorized to take action against platforms that do not comply. So that's the general approach there. On the next slide, I mentioned social platforms. Am I not? Okay, we'll talk about that for a second. The big sort of news from last week was about an ad involving Lieutenant Governor of North Carolina, Mark Robinson, who's now running for governor in that state. A YouTube ad launched last week that was paid for. Todd Stiefel, who's a millionaire there, under the Americans for Prosperity group. As you can tell from the clear disclosure at the bottom of the ad, but essentially that ad, which was developed through AI, references revelations that came out last week about comments that were allegedly made by Robinson on a porn site, a Black porn site known as Nude Africa, in which Robinson allegedly called himself a Black Nazi, talked about how he yearned for the restoration of slavery, enjoyed reading Mein Kampf. Robinson has responded that those were artificially generated by AI, that they're not true. But in the meanwhile, most of his staff apparently quit. There's been a huge amount of coverage. This was all announced through a CNN report linking Robinson to the site, but then was, of course, blown up through all of the press. So, this is an example of how AI can be used either to create, as Robinson says, advertising information out of whole cloth, however you look at it, based on one news site's claims, based on Robinson's claims. But these are the types of things that can come up in an AI generated world. Not only can technology make fake stories, allegedly fake stories, believable, but its existence helps those who want to make true stories seem unbelievable, as Robinson is trying to do. Invoking AI is yet another tool for Americans in the political sphere or otherwise to alter facts so that they align with a desired reality. So Trump has falsely accused Kamala Harris of using AI to generate an image showing a large crowd at a rally. He's recently reposted a doctored photo of Harris with accused sex offender Sean Diddy Combs, whose face is apparently superimposed on the body of Montel Williams. He shared a fake endorsement with Taylor Swift. So you can see how these fake images of politicians proliferate online. Because this technology sows doubt about reality, it can also provide a convenient dodge for politicians confronted by uncomfortable facts. So the social media websites have also, or platforms and websites have also adopted their own policies in response to both, situations like this and the state and federal laws regarding political advertising and AI. And that should be the next slide, I think. Google has probably the most extensive policy that requires disclosures. In some types of advertising, they will actually now automatically generate the disclosure for things like feeds and shorts on mobile phones, in-stream. They also suggest different types of potentially acceptable disclosures, Google does, for other formats like altered or synthetic content. This audio was computer generated. This image does not depict real events. Or this video content was synthetically generated. Meta and YouTube also now require labeling, and TikTok, does not permit political advertising as well. The networks and the broadcast networks review political advertising. So this is the type of thing that these are the types of approaches that the non-legal, shall we say, platforms take, informal platforms take. So in terms of best practices, we're still developing. The laws are still developing here, but advertisers should consider at the contracting stage in working with some of the PACs that are looking to post there or to post their content. This should be considered how to approach it at the contracting stage. The contract could address any liability associated with the use of AI. At the legal review, we should all be, looking at what disclaimers should be used. What does the content look like? Should tweaks be made? And then, of course, platforms should be considering whether they may face liability for ads placed on their platforms. And, everybody should be looking at the use of AI at the intake stage, screening it, looking at what kinds of disclosures are appropriate, developing protocols for handling AI when it's political AI, and following, of course, the developments of these laws, because we definitely will see new laws addressing political advertising, both before and after the election.
Great.
Thank you.
You so much, Melissa. So I apologize that we've gone a little bit over. We have one last presentation, but it's an important one, which is concerns about how AI can be biased, can further bias. And so we're going to hear from Kelly Harris in Canada, who's going to talk to us a little bit about that.
Thanks so much, Jeff. Hi, everyone, and thanks for joining. I'm Kelly Harris. I'm an advertising lawyer and principal at a boutique advertising law firm in Canada called Harris & Co. And before I dive into the super important issue of bias in AI, I did just want to start with a very quick update on how AI is beginning to be governed in Canada. We have several AI regulations and codes and guidance that are currently enforced in Canada. The first was the Federal Voluntary Code of Conduct from Innovation, Science and Economic Development Canada, which was issued in September 2023. And it identifies high-level principles that should apply voluntarily, of course, to generative AI systems while we await real enforceable regulation and legislation. And some of these principles include things like accountability, safety, transparency, human oversight and monitoring, validity and robustness, and notable for this discussion, fairness and equity. Some other recommendations in the code that might be interesting to the advertising community are that signatories agree to develop and implement a reliable and freely available method to detect content that's been generated by the system. So watermarking, which we're starting to see, and also to ensure that systems that could be mistaken for humans are clearly and prominently identified as AI systems. There's some other codes to keep in mind in this area in Canada. In December 2023, the Federal Privacy Commissioner also issued its principles for generative AI technologies. And this was just after some Quebec laws requiring disclosure and redress for automated decision-making came into force in September of 2023. And most importantly, we also do have some proposed legislation in Canada, if you could go to the next slide, please, called the Artificial Intelligence and Data Act. I think maybe the previous one slide, please. So this, maybe we're missing it. Well, I'll go through it. This is draft federal legislation that would require those responsible for high impact AI systems to assess whether it is one, establish measures to identify, assess, and mitigate the risks of harm or biased output that could result from the use of the system, and establish measures to monitor compliance with mitigation measures. And it's unclear, what high impact AI system would be. That is in not yet drafted regulations. But it would also, this legislation would also introduce some pretty large oversight frameworks, which would include ministerial powers to order audits of AI system, publish information to prevent harm, and impose administrative monetary penalties, up to 3% of global gross revenues. And up to 5% for certain offenses. So this would be a new AI commissioner that would be responsible for enforcement. This legislation is draft. It was proposed in June 2022, and it was on the back of a federal privacy reform bill. So it's taking a very long time to be determined, or to be discussed rather. It's currently in committee hearings in our first legislative chamber. So it's unclear whether this will be passed before the federal election, which is likely to be anytime between now and likely the spring, is what pundits are calling. If you go to the next slide, please. In line with the fairness principles in the voluntary code, the draft AI legislation in Canada does anticipate the issue of bias in AI. And it defines biased output as content that is generated or a decision, recommendation, or prediction that is made by an AI system that adversely differentiates an individual on a prohibited ground of discrimination, as defined in the Canadian Human Rights Act. And notably, there's a safeguard included in this that expressly carves out content that does discriminate, but prevents, eliminates, or reduces disadvantage that would be likely suffered by individuals or groups related to prohibited grounds. So you may ask, if you could go to the next slide, what are those prohibited grounds? Canada has both federal and provincial human rights legislation that protects individuals against discrimination on characteristics like race, ethnicity, religion, age, sex, sexual orientation, gender identity, marital family status, disability, conviction status. And there are some slight differences with provincial human rights legislation as well. So it is currently already prohibited in Canada to deny provision of a good, service, facility, or accommodation based on these, defined characteristics. And so a question arises, outside of this proposed AI legislation, could services include advertising? There's some legislative basis and case law basis for that. And therefore, are you increasing the risk of using AI if it could introduce bias throughout the entire advertising cycle, as we've heard from the other panelists, considering initial, AI generated market or competitive analyses, through to creative automation in images, media planning, and even media sales, all stages of advertising creation, ideation, and implementation. There's AI, technologies that are going to be part of that. So if you could go to the next slide, please. The first example of AI bias in advertising in Canada I'd like to raise is a Canadian government image published last year. So you can see it, the image in the bottom left of the slide, which depicts a woman who is wearing like a fur and a scarf, and it's beside a headline concerning the Canadian Arctic, which is home to many Canadian Indigenous communities, and more specifically the Inuit. And the problem is that that image is not really what Inuit people look like. And it, of course, came out that the image was AI generated, and Global Affairs Canada, the agency responsible for this image, issued a formal apology to the Inuit and Indigenous communities for the misrepresentation. They deleted the picture. And the woman, the real Inuk woman pictured there, is a filmmaker who responded to this controversy. And, she noted that every AI generator she has used with her photos make her look Asian. And she also raised the issue that actual human Inuk artists, in this case, it would have been a model, are being factually currently being replaced by AI. So, this incident shows that it's currently a reality that the use of AI in media has the potential to, number one, misinform, and number two, create discriminatory outcomes for racialized groups. If you go to the next slide, please. I think when we start to see AI taking over in many aspects of society, we as lawyers and leaders in creative industries it's helpful to look to analogies to try to predict the impact of AI, in the legal and advertising industries and communities. And we've already seen the issue of bias in AI, while not necessarily in the advertising context, making its way to Canadian courts and other contexts. One of the big issues that has already come up and has reached courts is discrimination in facial recognition technology. And there's a law professor at the University of Calgary named Gideon Christian. And in his research, he found that there is over 99% accuracy rate in recognizing male white faces in facial recognition technology, run by AI. But there's a much higher error rate when it comes to recognizing faces of color, and in particular, the faces of Black women. And there was a case in Canada out of the federal court last year in which Black women immigrants, there's a couple of them, who had made successful refugee claims in Canada, had their refugee status stripped on the basis that a facial recognition technology matched their face to some other person. And in this immigration decision, the court grappled with the use of AI facial recognition technology, and also, the requirement to disclose the use and processes of these technological methods. So, the court didn't resolve these issues. It's an ongoing conversation. It shows that the issue of bias in AI is already in Canadian, and I'm sure, as Hannah went through on the copyright side and in other jurisdictions in the courts in adjacent areas. And it's likely to continue to expand into other areas like AI discrimination in the context of advertising. And I'm just going to go to the next slide, and I'll leave it there given the time. But this slide picks up on what Hannah showed at the beginning to demonstrate the bias in AI image generation. And similar to Hannah, we use 3 different generative AI platforms to generate images using the prompts reputable Canadian lawyer, of which, if you look in the Oxford Dictionary definition, you would find Kelly Harris of Harris & Co. But AI had different results. We used Deep AI, OpenArt by OpenAI, who's the creators of ChatGPT, and Microsoft Designer, which is a Microsoft product. And of the 8 AI generated people in the images across the platforms, and we've shown a few of them, 75% appeared to be men and 100% appeared to be Caucasian. So this obviously raises questions around representation and omissions of minorities and perpetuation of stereotypes. And if you look into the research, it shows that using more representative data can substantially reduce bias in outcomes as well. But in the complex situation, like in the case of generative AI, programmers might not be able to explain how specific outputs are being reached, and it makes it difficult to audit and ultimately to fix them so that we can produce better outcomes. So given the tight timing, I'm just going to leave you with that thought. Thank you all for joining, and watch this space as this all develops.
Thanks so much, Kelly, and thanks so much for everyone for participating in this panel, and thanks to all of you for watching and for sticking with us as we dug into AI in the Americas. We hope to see you back here in the next couple months for our final webinar in the series. So thanks again. Bye. Thanks, everyone.
Bye, guys.